Excuse me. Thank you, Mr. Chairman, and thank the witnesses for their presence here today. We've got, of course, three branches of government, all of which are co-equal and all of which are incredibly important to our democracy. But we also have a fourth estate, as sometimes the media has been colloquially referred to, which I think also plays a very important role in our democracy and projecting that outward and making sure that people are informed about the things that are occurring, certainly with the executive branch and with the legislative branch, and hopefully increasingly as it relates to the judicial branch. And so, Judge Robinson, I just wanted to ask, do you think that the role that the media plays in the context of helping to bring our democracy to life is a point worthy of consideration as we determine the best way to proceed?
Absolutely. I'm a J school graduate, so that's an easy answer for me to give. But I think also it's important to note that our pilot, this pilot, provides for video recordings pushed out on the uscourts.gov website, available to everyone. Not just those recordings that the media has decided to record that they think are interesting enough for people to their subscribers or to the public to listen to. We've evolved as a nation. We've evolved as an institution. 20 years ago when we did that first pilot, it was based on media recording. We made a very deliberate decision this time to not have recordings based on what the media wanted to record, but to make all recordings that meet the requirements of the pilot pushed out to the public. I mean, what we have found is that the media now is much broader in terms of their public reporters, in the sense of people that tweet and people that report and people that create YouTube videos and all of that sometimes actually find themselves in the hands of the media, and they're used by professional journalists to report on the news.
Now, we have three branches of government, as I mentioned, all of which in our founders' wisdom are separate and co-equal. Does the Judicial Conference take a position on whether it's appropriate for Congress, a different branch, to be making determinations about the best way for a separate and entirely co-equal branch to proceed as it relates to cameras in the courtroom? In other words, is there a separation of powers concern that should legitimately be considered in the context of this debate?
With respect to the trial courts and the circuit courts of appeal, we haven't raised a separation of powers argument. But what we have asked is for you to let us study and then formulate policy on the basis of our experience as further informed by the study itself. Case management, while it's clear that Congress promulgates rules that govern what goes on in federal litigation, at the same time, we also need to be in control of our case management practices and how we can best go about controlling what happens in the courtroom to ensure that the parties receive a fair trial. And so that's why it's not so much a separation of powers argument, but an argument that you give credence to the fact that we're studying this, that we are experts, if you will, in what happens in the courtroom, and that we want to make sure that whatever policy we formulate is shaped and informed by our experience and our information.
And is there a legitimate distinction that can be drawn between criminal proceedings and civil proceedings such that perhaps a greater degree of access is allowed on the civil side because some of the concerns that may be implicated that we need to think through in the context of a criminal trial, particularly as it relates to confidentiality and privacy and the adverse implications of unwanted exposure, don't necessarily exist on the civil side?
We have concerns with respect to the effect on witnesses and particularly the effect on the substance of the witness's testimony in civil proceedings, but we have more concerns on the criminal side. And that is because we have witnesses, as I mentioned before, that are confidential informants and cooperators. We have undercover officers and agents who routinely testify in criminal cases. We're very concerned about their security and safety.
And Mr. Oestreicher, is it legitimate for the parties who are participating in the actual trials to have an opportunity to object based on their determination that the presence of cameras in a courtroom will complicate the ability for them to receive a fair trial, or should we completely dismiss the concerns and simply just allow a judge to be the arbiter?
Once again, I think that the trial court judge could make that decision. The problems that I see are if everybody objects, we're not going to have very much of a pilot study for them to have some evaluations from. So, you know, my experience in state court in New York was many times when the media made an application to cover it, you could certainly expect out of hand that there would be an objection. And we would make those arguments to the judge, and the judge would decide with a presumption of coverage whether or not that the objection would overcome that presumption. So I think that might be a good way to start. I just also wanted to go back to one other point in terms of the media deciding which cases to cover. That's true, but what's also true, at least in my understanding of this pilot program, is that none of the video that's recorded in any of these cases gets posted to the website until the judge in the case has reviewed the video. So in a way, if there's something there that might be problematic, that's something that, you know, he or she could do as well.
Thank you. My time has expired.
Thank you, Congressman. The chair